Oh, Senator Babavne is here. I'm sorry, I didn't see you. You were on the far left.
Senator Member Babavne has item 2. It begins.
Chairwoman, Senators, good morning.
Thank you.
I'd like to just present AB 160, which will stop counterfeiters from profiting from their crimes, will hold them financially liable, and capture tax revenues lost as a direct result of their criminal activities. California is home to many key industries which are prime targets for organized counterfeiting and piracy. For example, the film and television industry, which provides over 190,000 direct jobs and over $17 billion in wages. California every year loses an estimated $3.3 billion a year as a result of piracy crimes here in California. According to California law, if a prosecutor can show that a defendant's money consists of ill-gotten gains derived from specific criminal activity, then the money is subject to forfeiture. Currently, there are 33 different crimes that can trigger forfeiture of these ill-gotten gains. AB 160 will expand that list to offenses to include piracy and insurance fraud. In order for forfeiture of criminally obtained assets to be allowed, the trigger crime must also be committed as part of an organized crime plan. But there are only 12 different offenses listed organized crime that can fulfill this definition. The bill would add more white-collar offenses to the definition of organized crime to ensure that prosecutors are able to seize unlawfully obtained assets of these criminal operations. AB 160 strengthens the law to better equip the state to combat California's growing underground economy and give the state the revenue it deserves. It is strongly supported by Board of Equalization Chair Jerome Horton. I respectfully ask for your aye vote to make sure that California is making sure we get fully implement all our laws to make sure that ill-gotten gains from things like piracy, insurance fraud are not put back in the hands of criminals, but rather put back in the coffers to make sure they're going to the public services we all enjoy. Thank you.
Thank you. Let me just say, as far as I know, there is no opposition to this bill.
I appreciate
so
that.
I would urge
That means be
speakers
brief.
to be brief. Yes. Speakers in support of the bill.
I'll go in support. David Hunter, Senior Legal Counsel for Chairman Jerome Horton, State Board of Equalization. We enthusiastically support this bill. We cannot support it enough. Assemblymember Babavne is adding teeth to this bill with the forfeiture provisions, and this is the way to combat the underground economy in this state. Thank you.
Thank you.
Sean Hoffman with the California District Attorneys Association. I'd echo what Mr. Hunter and Assemblymember Babavne said. It's an important modernization of the statute to reflect the current state of criminal activity in California. It makes it a more useful statute for prosecutors and law enforcement.
Thank you.
Good morning, Madam Chair and members. Corey Salzillo here on behalf of the California State Sheriff's Association in support of the bill.
Madam Chair and members, Terry Thomas on behalf of the Motion Picture Association of America. We welcome every additional tool to combat piracy in this state. Thank you.
Thank you. Are there others in support? Please come forward. And are there speakers in opposition? If there are any, please start to come forward.
Hi, Madam Chair. Ryan Sherman on behalf of Los Angeles County Professional Peace Officers, Long Beach Police Officers Association, Sacramento Beach Sheriffs, and the California Fraternal Order of Police, all in support. Thank you.
Thank you. Are there speakers in opposition to the bill? Seeing and hearing none, are there questions or comments from members of the committee? Senator Anderson.
I just have a quick question for you. Why shouldn't all the money that's recouped go towards restitution? I'm having difficulties with this only because I was thinking, because of this one question. So what I'm really asking is, as we collect the funds, the ill-gotten gain, why shouldn't that go 100% to restitution?
Why shouldn't it, is what you're asking?
Yeah.
These crimes sometimes take on different forms, and obviously the money that comes in takes on a different type of track record in terms of trying to determine where the money came from exactly. I think some of the money will go for restitution. Some of the money, though, will be very hard to determine exactly how to pay restitution in a fair manner, and that money should go back to the state to go towards the services that make sure that our state has the ability to put more money into law enforcement to stop these crimes, more money into task force that can really prevent these crimes happening in the future. A number of the victims in these crimes obviously would appreciate the restitution. I think what they'd appreciate more is having an ability for our law enforcement agencies to make sure these crimes never happen in the first place. I think for many of the victims in these crimes, they'd rather see more robust laws to prevent piracy, to prevent these counterfeit organized crime operations from happening than just simply receiving restitution on the back end. That being said, where it can be fairly paid back as restitution, I hope this law will allow it to do so.
Okay, are there other questions or comments, or is there a motion on the bill? The bill has been moved. Would you like to close, Assemblyman?
This bill passed in a very bipartisan manner on the floor of the Assembly, and I appreciate your aye vote today.
Thank you. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Glazer. Glazer, aye. Leno. Lou. Lou, aye. Monning. Monning, aye. Stone.
Aye.
Stone, aye.
Thank you very much. Assemblywoman Campos. Yeah, I'm going to hold the roll open for the absent members, but there are enough votes to pass. Good. Assemblywoman Campos, as you know, your bill is double referred to Senate Judiciary. And I noticed in the back and forth, there are a number of issues that were raised that really should be more appropriately, I think, addressed in the Judiciary Committee. A lot of speculating on what courts might rule and have ruled and could rule. But I would hope that in this hearing, we could really focus our testimony on the provisions of the bill that specifically fall under the jurisdiction of this committee, which are primarily CDCR noticing of victims when that reporting happens. But having said that, please go ahead and present your bill.
Thank you, Madam Chair and members of the committee. I present to you AB 538, a bill that seeks to protect crime victims and their family members from being re-victimized by limiting the opportunity for criminals to profit from their crimes. Existing law does not effectively protect victims and their surviving loved ones from the commercial exploitation of violent crimes for entertainment purpose, allowing victims and their next of kin enough time to pursue civil actions against their offenders is the only right way to do this. This bill will extend the statute of limitations to 15 years and would require the victims and their next of kin to be notified when a contractual agreement is made for the sale of their story of the crime that they have committed. I have witnesses with me, and I strongly hope that you can find in your vote today to vote aye.
Good morning, Nina Salerno with Crime Victims United. First of all, to address the chair's main question about CDCR notification, this bill does not place any extra burden on CDCR. It actually is the burden of the victim to keep CDCR notified, first to request notification of any type of thing associated with the inmate or the parolee that committed harm. It does not change that requirement. The burden still falls on the victim to request CDCR to keep them updated of anything. So therefore, it would be very easy for the notification for any of the movie industries or media industries. All they would have to do is simply contact CDCR for the victim information. The importance of this notification, and as a victim of crime, it is very important for the victim to be emotionally prepared. And that is the purpose of the notification. Without this notification, as you'll hear testimony today from Ms. Avila, who is the victim that was the genesis of this bill, that it is an emotional turmoil to all of a sudden find out that the perpetrator of your crime is making profit off the murder or off the rape or off the child molest, and then to have it put out in media and not even be notified. It also allows the victim to prepare to take action as our Constitution and as our laws allow under the current Code of Civil Procedure that allows a victim to recover. But most importantly, I think, and this is a vested interest for the state, It allows the victim to seek restitution. And our state constitution, as codified under Marcy's Law, Proposition 9, says that the victim has an absolute right to seek restitution. It also says that is an essential function of the government to provide that the victim has the opportunity to seek restitution. This is an essential government function. It's also essential to our government because seeking restitution from the perpetrator of the crime is what not only makes victims whole, it allows what victim compensation to continue to do their important work. It is also important to note that this bill in no way hampers free speech. The victim has no veto power. The victim cannot say whether or not the book can be written. The victim cannot say whether or not the movie can be done. All this says is that the victim has a right to be notified, and should the victim choose to enforce the rights to restitution, what you have to remember is at the time of sentencing, restitution is left open for a victim to come back to court so that, in fact, if there is a way to recover, there is a way to recover. That is what this bill allows. And it allows the victim to be prepared emotionally. It allows the victim to look at their rights and decide whether or not they are going to enforce them. It does not allow the victim to veto what the perpetrator's rights are. It just gives them an equal playing field. And it allows that a perpetrator does not unduly profit from their crime should the victim seek any type of restitution. I would strongly encourage you to pass this. And Madam Chair, if you have any other questions about the CDCR notification, I'd be happy to answer that as well.
I didn't particularly actually have any questions.
Okay.
I just wanted to note.
Okay, I just wanted to clarify
so we
that.
wouldn't end up with a very freewheeling discussion about things that aren't actually in the purview of this committee.
Okay.
But thank you. You were, your testimony was very clear. Others in support.
Good morning. My name is Siobhan Avila. I flew in from Los Angeles this morning. I'm here to represent my family, the Avilas. My sister-in-law, Missy Avila, was brutally murdered in 1985. She was tortured to death by actually what happened to be her longtime best friend, Karen Severson. Severson moved in our home after she killed Missy and actually helped try to solve the crime. 3 years went by, and then we found out that it was actually her. It was trauma to our family in a way that, you know, you can't even imagine that the killer is actually living in the home with you. So she received second-degree murder, and in 2011, she was released from prison after serving 23 years. Immediately after release, she wrote a book and then another book, and we found out that she has a documentary in the works. The books, I have had to hire an entire team to sort of follow what she's doing, and her books slander and re-victimize Missy and my family all over again. She came out of prison thumbing her nose at the law, and the law is on her side. And this bill doesn't infringe on the First Amendment right. It simply adds more time for victims to take action against the perpetrator, as well as alerting the victims of the perpetrator's intentions. This is just the tip of the iceberg to what is a very serious problem. Crime is paying in California. Most people assume that there are laws in place to prevent criminals from profiting off their crime, and people are in shock when they find out that this is happening. Crime should never pay. There is already too much chaos and corruption in this world. A criminal profiting off their crime will only add fuel to the fire. Reliving this murder through the eyes of a non-remorseful killer has been a living nightmare. Our family doesn't want this to happen to anyone else. We need your help. We need this bill to move up to Governor Brown's office to bring awareness to this very serious problem. Thank you.
Thank you for coming and for sharing your story. Others in support.
Madam Chair and members, Corey Salzillo here on behalf of the California State Sheriff's Association in support.
Okay. Are there others in support of the bill? Are there speakers in opposition to the bill? Please come forward. Please come forward and sit at the table. We can have two speakers. for about 2 minutes each, and then I'm going to ask for Me Too's. So you can decide. Okay, please.
Chairwoman Hancock, members of the committee, my name is Melissa Patak. I am here on behalf of the Motion Picture Association of America and our member companies, 20th Century Fox, Disney, NBC Universal, Paramount, Sony Pictures, and Warner Brothers to explain our opposition to Section 2 of AB 538. At the outset, please note that we have no objection to Section 1, and we respect the effort to maximize the ability for victims to recover restitution. And I understand the Chair's admonition not to delve into the constitutional issues, but we have, I feel it's important for the record to state our concerns, and in previous bills, we've had the opportunity to state similar constitutional concerns. Thank you. We believe Section 2 violates the First Amendment because it singles out and burdens protected speech. The bill requires the reporting of a contract for story rights, clearly protected speech. The purpose for reporting such a contract is for the state to notify the victim that the felon has earned money, but not any money, only that money from First Amendment speech, so that the victim can bring a civil suit for restitution. This is squarely within the Supreme Court's decision in Simon & Schuster, as well as the California Supreme Court's decision in Keenan. Both decisions are thoughtfully explained in the committee's analysis. Section 2 will also have a chilling effect on speech, as noted in the analysis. A felon may have additional information to tell as part of his or her story of the crime, as Keenan notes, rehabilitation, redemption, experience with the criminal justice system, and warnings to others. All of that would be reached by this bill if the felon's story included the crime story. Section 2 is over-inclusive and fails constitutional analysis. The state's interest in restitution for victims is an important interest. Even under a lesser standard of analysis than strict scrutiny, there is a very strong likelihood that AB 538 would be found to be unconstitutional because there are less restrictive means to provide information to victims. Penal Code Section 1202.4 could be amended to require a felon to provide periodic notification of financial information even after he or she is discharged from prison and parole. This puts the responsibility on the felon and would cover all income and earnings, such as an inheritance or other wages, and other ways a felon might exploit the crime, as noted in Keenan, including the sale of memorabilia or other personal effects. We would urge the committee to amend the bill to remove the constitutional defects. MPA is joined in our opposition by the American Association of Publishers, as well as the Media Coalition, both of which are based in New York and could not be here today in person. I'm happy to answer any questions.
Hi, my name is Andrea Richardson. I'm with Legal Services for Prisoners with Children. I'd like to split my 2 minutes with a member of All of Us or None. I would ask the committee to consider amending or taking out Section 1 of this bill and ask you to consider what real impact beyond a largely symbolic increase to a person's overall sentence that section would make. I want to emphasize that victims do have the time of trial, incarceration, and parole, and that can, and for most violent crimes, is a period of decades to file a claim. In addition to that, they have another 10 years following a person's successful discharge from parole to bring a claim. And it's unclear to us how many people who do not bring claims within that period of trial and incarceration and parole, as well as that additional 10 years, don't bring claims but would bring a claim within that 5-year additional period. But what we do know is that that 5 years would certainly add, another 5 years to someone who has finished their sentence, successfully finished parole, and finished those 10 additional years. It would add 5 more years before they're able to really finish their sentence. And I understand, I do just want to say that people's sentences have to end at some point. They can't just continue to be prolonged. So we would ask you to delete that provision.
Yeah, my name is Deirdre Wilson. I'm representing All of Us or None. I'm a formerly incarcerated person myself and a survivor victim of crime myself. And I want to say first, in all due respect to all victims, and I really appreciate that you came and what you've been through and what this bill represents to you. However, I feel that there are a lot of things mixed in here that is like taking a very emotional, charged issue and casting a very wide net legislatively that's going to impact so many other people in negative ways that are serving sentences, that have paid for their crime by doing their time and are trying to get their lives back together. And if this could impact so many people, for instance, myself, just to give you an example of how this can play out when you, I'm glad you referenced Marcy's Law, because I'm not sure that that has had the effects that it was intended to really address victims' needs. I've seen the harm that it's done to lifers that I work with that have had
Thank
their
you.
double sentences.
I am going to have to go and present 2 bills in public safety. So if we're going to have a very extended discussion, I'm sorry, I had hoped to be here for the discussion. This is the way the legislature works. Senator Anderson.
Just to finish that. Okay, thank you. I served a sentence of 5 years. I got out. I applied for a job with a woman who hired me for in-home care. At that point, there wasn't the law in place that makes it illegal for someone who has not been 10 years outside of their release from their conviction to hold those jobs. I successfully performed duties for her. 9 years later, she asked me again to work for her, and it is now legal for me to do so. And I appealed that, and the appeal was denied. So that law has prevented me 10 years later after my conviction from getting on with my life. So I'm just really concerned that with this law, so much damage to people's lives is going to occur, and the real needs of victims and this issue of when people make a story out of it, that seems to me like a whole separate issue from what should be passed into legislation.
Thank you. Do we have any more witnesses in opposition?
Yes, Mark Powers with the California Broadcasters Associations. We feel that there's been little evidence offered to show that the current system isn't working. And if you're going to place an administrative burden somewhere, it should either be placed on the felon or perhaps the government income reporting systems that are already in place. Thank you.
Members, do you have any questions? Senator Glazer.
Thank you. I support many of the intentions of the bill in terms of notification, in terms of extending the statute of limitations. But where I was having trouble was putting the burden on the person making the contract versus putting it somewhere else that might be more appropriate, including the state. If someone is paid for their story in some fashion, isn't that a reportable event to the state? And if so, isn't that a better burden to place on our behalf in terms of the notification than it is on a private individual?
First of all, I appreciate your question, and I think that the essence of the bill is, not to, as the attorney in the room stated, is not to put the burden on the state, but actually to make sure this bill is more to make sure that the victim and the victim's family have the right to be notified. I've listened very clear on the testimony as it's gone through one house and now in the other, and I think that the victims are getting lost in the dialogue, and their kin is getting lost in the dialogue. This is to give them the right to be able to know when an individual, in this case, it's Missy's life that we're referring to, and her kin, to make sure that they have the ability to know when the person that committed the crime is released from prison, and that they have the ability to know
that if they are entering into a contract with a studio or anyone on the story, that they have the right to know that that is happening. Because I think even as her sister-in-law stated, that as they've had the opportunity to read the story, there is information in there that is not accurate. And whether it puts the burden on the state or whether it puts a burden on the person that committed the crime, I think that we need to look at this, that it really is basically giving them the opportunity to have years to be able to process this. I'll let the attorney from a legal standpoint answer the rest.
I think too, if I understand your question, you thought that there's another mechanism for notification. The problem is then that burden is placed on the victim. Although a contract, just like any reportable income is reportable, you wouldn't know about it. I mean, I don't think most people think that the killer of their loved one is going to enter into something, so they wouldn't think to look at it. So again, this is an easy fix. The people that enter in the contract simply have to notify, get the information from CDCR. If the victim does not have their information on file, then it's I don't mean to say that, it's a non-issue. Meaning that if they contact CDCR, CDCR says we have no victim information, there is no further burden on the contractual people then.
Right, but the trigger is the financial contract, and I'm asking if the trigger was payments, wouldn't the state therefore then have knowledge of that and have the data that there is a restitution issue in play?
Not necessarily, because restitution is sometimes left open, and so it's not a trigger within the CDCR system.
And that's for me where I think I'd find a more supportive place for me at least would be to create a burden on us rather than the burden on a private individual that may not have any knowledge of the systems. I mean, if a state agency isn't talking to another state agency, that's our responsibility. But to communicate the obligations within this bill to anyone that's out there that might engage in this conversation with someone who is a perpetrator of a crime, it just seems like I want this effort to be successful. I want victims to have the ability to seek restitution, and I also would like victims to have the ability to have as much notification as reasonable. And so I'm trying to identify maybe a different trigger that could be in play that would allow you to achieve the goals in which you seek, and that's why I'm having trouble.
And I appreciate your support. Again, though, I think it's a complex system, the restitution and the CDCR systems, and unfortunately, it does slip through the cracks, because then you are placing the burden basically on the perpetrator to notify the parole agent, then to notify the Board of Prison Terms. It would be, I think it would get lost in the chain is the one problem.
Just to be clear, I'm not trying to put an additional, I don't mind putting additional burden on the perpetrator. I'm trying to say if that person is compensated, and the issue is seeking restitution, it comes from a form of compensation. And if that's a taxable event, it requires, under our current tax law, notification of the state, either through a 1099 or some other notification that that person has been paid. That seems to be a place in which we could make sure that our interests are aligned in terms of awareness of that perpetrator's potential for restitution, and therefore that's a place that can then go through the notification system so that a victim has an opportunity to seek restitution. That's all I'm saying. It seems like that's a clearer track to me than to somebody out there who may be having a conversation with someone on a book deal or a movie deal. Somehow they would know all of our laws and obligations that would come of that outside of the tax laws. It just seems like that's maybe not as effective. And I'm trying to find a way that might be more effective.
So, Mr. Senator Glazer, this was not brought to my attention in any other committees, and that we've, this issue that you're bringing up. I'm more than happy to sit down with you personally and see if we can address your issue. This bill is extremely important, I think, not only for the Avila family, but I think for families across the state of California. We've crafted this policy to address what we believe is the essence of what will make the families be able to get notification
that issue about if there is profit from it and who has the whole tax thing, that was not something that was brought up by any committee or experts within the assembly. But I'm more than happy to sit down with you to hear your concerns and spend a little bit more time. They did say it's double referred, so that does give us a little time. I know that that's probably not in the area that Senator Hancock was talking about, but I'm more than happy to sit down and hear your discussions with more time.
Thank you for your thoughtfulness, and if it may have the votes to go forward. If it doesn't, then maybe that provides the opportunity for me to have that conversation, so we'll see where it goes.
Thank you.
Any additional questions? Senator Leno, you gave me the eye. Does that mean you wanted to speak?
I think you read my mind and my eyes. Thank
Excellent.
you. Thank you, Senator. I just wanted to ask Ms. Patak a question.
Sure, thank you.
I was taking notes as carefully as I could, so I think I got it right. But with regard to Section 2, I think you said something like, so that the notification requirements are such so the victim can bring a civil suit.
Correct, and that's not in the bill itself, but
Right,
that...
I just want to clarify, that is not in the bill.
Right,
There
but-
may be a civil suit, there may be not.
But that's the purpose of the bill, is so that the victim, there's a pot of money, that the victim sees that there's money and resources, and then they'll sue. I mean, the other possibility is that the victim can sue and get a judgment, even if the felon is judgment-proof. In the future, the felon may have resources, and they could go, execute that judgment. So there are less restrictive ways to ensure that a victim get compensated. This bill just spills over into the constitutional free speech issues that are very important to to our member companies.
That's in debate, and as the chair had mentioned earlier, we're not here to debate the constitutionality.
Right,
but I just wanted to clarify, so the victim can bring a civil suit is not in the bill. It's your
Yes.
understanding.
But that's the purpose, and that's what
I just want to make
what
the
they want
point,
to do.
and I'd ask any of the proponents to comment otherwise, that if I'm in that situation, whether I bring a suit or not, and I may not want to, I prefer to be notified because I've already put my name on a list that says I'm a victim who wants to be notified if this, or this happens, because I don't want to read about it in the newspaper. It's an insult. It re-initiates the entire grieving process. And so there's reason, aside from bringing a civil suit, you're representing your clients well. You're concerned about civil suits, but just keep in mind, there could be benefit, there will be benefit to notification of these victims, whether or not they bring a civil suit, because they should have at least that respect.
I understand. If I could just make one comment on how...
And thank you, Mr. Chair.
How it may work in the motion picture and television business is somebody may have an idea. They may go out and interview someone. There may be a contract. Somebody brings the idea back to somebody who's the decision maker, and the story may never get made. Never get made. And in the movie business, that happens more often than the movie actually gets made. And so now you've got this burden of notification, and the story may never get made. The family may never have to go through that. So again, we're very sympathetic. Just believe that there are other ways to accomplish the goal.
So that's an interesting point, and I appreciate it. I would just ask the author, and I'll probably see you again in judiciary when the bill gets there, but maybe there is reason to consider an amendment, because why burden a victim with some machinations of a studio that don't ever amount to anything? Maybe the notification should be upon if and when actually something goes forward. I'm just imagining if I were in that situation, I probably wouldn't want to be troubled if it's just some lawyers talking to each, excuse me, I'm not denigrating
Okay.
there, just some business people talking about an idea, but it doesn't come to fruition. How about when it comes to fruition?
Could I speak?
Oh, of course, of course.
Just address that. I've been with the Avila family since the inception of this, and the way they found out was absolutely devastating and appalling. It was through social media, and actually the contract had not even been booked. but the perpetrator floated out there that she was talking to everyone and things like that. So the idea to say, well, just we're going to wait to see if 20th Century Fox is going to run with it. The other problem is they may run with it past the statute. This really isn't about compensation. Yes, it's nice for the victim to have the ability. The majority of victims don't always put themselves in civil lawsuits. And to answer the question about judgments, it is one of the hardest things for a victim to do is to convert restitution into a civil judgment. It's one of the most complex things in the law. It's tremendously burdening. I would also remind that in our state constitution, a victim is to be treated through the entire system with dignity and respect. This is just a component of that. To be a victim of a crime, and then when I sat there with Siobhan, and to have the social media flying out there, to have pictures that were stolen from their house of their murdered sister in a book that didn't even tell the truth. I can't tell you how that devastated the family. And that's the main issue of this notification. I don't see it as a huge burden for an industry to make a phone call to CDCR to say, we have booked a contract with this murderer or this rapist with the Night Stalker, and if you have the victims, they need to be notified. That's all we're simply asking. So I don't think it's a huge burden. I think their lesser restrictive arguments place the burden on the victims, and that is unfair. The victims have been burdened enough through our system.
Right. No, I should have prefaced my comments. I'm in full support of the bill. But thank you for helping me walk through this exchange with Ms. Patak, because I do understand that even without a contract, with the fact of social media, it's not a story in a newspaper until it becomes a real deal, but that there's chatter because the perpetrator was initiating the chatter. And that re-victimizes again as well. So I'll drop my suggestion.
Well, and I appreciate, I
Senator
mean,
Leno,
that's,
would that be a motion?
I'm happy to move the bill.
Okay. Would you like to close?
well, I was just going to say that Senator Leno, I appreciate the dialogue that we've had, and I appreciate the fact that you did bring that up. I'm glad that you're removing it, your suggestion. But it got into another area of why this bill is important. I mean, you can't control what the perpetrator has done, or the individual that committed the crime, and what they do with social media and other ways of communicating with the world. And this bill will make sure that the families are not re-victimized over and over again, to just be notified and know that this is coming, so that they, as a family, can be able to prepare themselves mentally for what may be down the pipeline.
Right.
And I respectfully ask for your
And
vote.
thank you, Nina, for clarifying that, substantiating my suggestion that this is not just about bringing civil suits. It's about respect for the victim. And there may be a civil suit, there may not, but there's valid reason for this independent of that.
The motion is to pass to judiciary. May we have a roll call vote, please?
Hancock. Anderson.
Aye.
Anderson, aye. Glazer. Leno. Leno, aye. Lou. Monning. Monning, aye. Stone.
You have enough votes to get out, but we're going to put it on call, so Senator Hancock.
Oh, I need one more. I think
The
I.
bill's on call.
Yes.
We don't work a lot together. So.
I think, Mr.
Thank you very much.
Thank you.